Hello, very good afternoon to you. I'm Ben Brown reporting live from Westminster. Well, in a landmark ruling today, the government has lost its appeal at the Supreme Court just across Parliament Square over who has the authority to start the process of taking the UK out of the European Union. 8 of the 11 Supreme Court judges ruled that only MPs and peers here at Parliament, not the government, have the authority to trigger Article 50 and so begin 2 years of negotiations on leaving the EU. The President of the Supreme Court, Lord Neuberger, said that leaving the EU would change UK law and the rights of UK citizens, and that, he said, meant that Parliament has to be consulted, has to have a say. Well, a short time ago, MPs were told that the government will now, as a result of that Supreme Court judgment, introduce legislation within days to start the formal process of triggering Article 50 and leaving the EU. Our political correspondent, Carol Walker, reports on the latest.
This was a case with profound implications. Who should decide the process for taking the UK out of the EU? The decision, taken by 11 of the most senior judges in the land, was delivered to the hushed courtroom.
Today, by a majority of 8-3, the Supreme Court rules that the government cannot trigger Article 50 without an Act of Parliament authorising it to do so.
Article 50 begins the formal negotiations for leaving the EU, a process which the judges said would fundamentally change UK law.
The referendum is of great political significance, but the Act of Parliament which established it did not say what should happen as a result. So any change in the law to give effect to the referendum must be made in the only way permitted by the UK Constitution, namely by an Act of Parliament.
The verdict was clear. The judgment spelt out why the court had rejected the government's case.
So the government will comply with the judgment of the court and do all that is necessary to implement it.
The woman who brought the case said the ruling reaffirmed that Parliament is sovereign.
This ruling today means that MPs we have elected will rightfully have the opportunity to bring their invaluable experience and expertise to bear in helping the government select the best course in the forthcoming Brexit negotiations.
Is this a blow to the government's Brexit timetable, sir?
But the government will be relieved that the court ruled there's no legal requirement for it to consult the devolved nations, Scotland, Wales and Northern Ireland. So the focus now switches to Parliament. MPs and peers won't try to block the Brexit process, but they could delay it. Opposition parties are already setting out the changes they will try to make to the coming legislation. Changes which could affect the government's whole approach to the negotiations over Britain's departure from the EU.
We're very clear. We're going to hold them to account. We're going to hold them to account to protect jobs. We're going to hold them to account to make sure British industry does have market access. And we're not going to allow ourselves to become some kind of offshore tax haven. That's not what people voted for.
Unless the government concedes a new deal for the British people, so that the British people have a say over the final arrangements between the UK and the EU, I will vote against Article 50.
The SNP say they will table 50 amendments.
The Prime Minister set out last week a path towards the hardest of hard Brexits. I don't believe there's a majority for that in the House of Commons. I certainly don't believe there's a majority for that across the country. So this is an opportunity for the House of Commons to assert itself and to have a say not just on the narrow question, but on the broader terms of negotiation as well.
Downing Street say today's ruling will not affect the timetable for Theresa May to begin negotiating with other EU leaders. The government will introduce a bill in the Commons within days.
This will be the most straightforward bill possible to give effect to the decision of the people and respect the Supreme Court's judgment. The purpose of this bill is simply to give the government the power to invoke Article 50 and begin the process of leaving the European Union.
But the scene is set for some tough parliamentary clashes before the bigger battles with the rest of the EU can even begin. Carol Walker, BBC News, Westminster.
Well, let's talk first of all about that Supreme Court judgment that we got at 9:30 this morning from Lord Neuberger, the President of the Supreme Court. And our legal affairs correspondent Clive Coleman was with me listening and watching that. Really a historic judgment, wasn't it? Constitutionally, legally, politically as well. 8-3, was that sort of result that you were expecting? Defeat for the government and victory for Gina Miller?
Yeah, I mean, I was expecting the government to lose. I think the reason for that is that they, unfortunately, were having to argue, in effect, against the principle of parliamentary sovereignty. Now, we don't have a written constitution, we have an unwritten constitution, but the core bedrock principle at the root of our constitution is that Parliament is sovereign. Parliament creates the law, it makes the law, and only Parliament really can do away with that law. Now, the government had an ingenious argument, a clever argument, and it was built on a number of very interesting academic articles that were written following their defeat at the High Court. Effectively, they were saying that, look, this law is not quite domestic law, it's sort of treaty law. The rights enshrined under the 1972 European Communities Act are not like buttoned-down statutory rights and a good old British Act of Parliament. They're treaty rights. It's a sort of movable feast, and because treaties are created or entered into by the government using this prerogative power, this executive power, the argument is you can reach in and pull those rights out and change that law using the prerogative. Now, there were some very, as I say, there were some very creditable and credible academic arguments and articles that backed up the government's position. So the 8-3 result, I think, reflects the problem that they had, but also the fact that that argument was attractive to 3 of the justices.
All right, Clive, for the moment, thank you very much indeed. Well, immediately after that, David Davis, the Brexit Secretary, came to the Commons and outlined what the government's response to that judgment from the Supreme Court will be. He said that shortly the government would be introducing legislation. We gather that will be within the next few days, and it would be a straightforward bill, he said, on triggering Brexit.
Now, if I may just pick up on the point that the honourable gentleman quite properly raised, the issue of our judges. I think I mentioned at length 3 times in my statement that this is a nation of the rule of law, a nation in which the independence of the judiciary is important, and it's something which is watched in this country by other countries as an example to themselves. So, and of all the people he could criticise that, I don't think I'm at the front of the issue.
So that was David Davis, the Brexit Secretary, saying it would be a straightforward bill, Clive Coleman, but you know, we know that really not much about this Brexit process so far has been straightforward. There are potential pitfalls for the government ahead.
Well, there are. I mean, any bill, however straightforward, 1 line, 2 lines, can be amended, and it's already been indicated that Labour are thinking about amendments, the Scottish National Party thinking about amendments. So, you know, you can get legislation through Parliament very quickly. The bill known as Dripper got through in 5 days. But the problem here for the government is, look, today they have lost control of the process. They didn't want it this way, but this is the way it has ended up. And this decision today places much more control in the hands of Parliament, and it takes it away from the government. And, you know, that is going to be a concern. I think it's going to be a concern in terms of the nature of the amendments that they have to face, but also in terms of the timetable, because it is now by no means certain that they can meet the timetable set by the Prime Minister to trigger Article 50 by the end of March. David Davis saying that that will be met, but who knows? Well, and the SNP are actually saying they've got 50 amendments to whatever bill is put forward to Parliament, 50 amendments that they've got lined up their sleeves. Well, anyway, after we heard from David Davis, the Brexit Secretary, in response, we heard from the opposition, from the Labour benches, from the shadow Brexit Secretary, Sir Keir Starmer.
Mr. Speaker, if the Prime Minister fails in her endeavour, the cost will be borne by families, working people and communities throughout the UK. The stakes are high, and the role of this House in holding the Prime Minister and the government to account throughout the process is crucial. Yes. Labour accepts and respects the referendum result and will not frustrate the process. but we will be seeking to lay amendments to ensure proper scrutiny and accountability throughout the process. That starts, Mr. Speaker, with a white paper or plan. A speech is not a white paper or plan, and we need something to hold the government to account throughout the process. Can't have a speech. Can't have a speech as the only basis for accountability for 2 years or more. That's the first step. There needs to be a reporting back procedure, and there needs to be a meaningful vote at the end of the exercise. The government should welcome such scrutiny, not try to resist it, because the end result would be better if scrutinised than it would otherwise be.
So that was Sir Keir Starmer, the shadow Brexit secretary, and he said in that speech in the Commons what a waste of time and money the government's appeal to the Supreme Court was. But the government said, well, they needed to clarify all this.
Yeah. I mean, it's undoubtedly the case that had the government, having lost the case in the High Court in November, have introduced a bill at that time, they would have had more time to meet their own timetable. But it is perhaps a little rich to say it was a waste of time and money. As we were just discussing, there were some very credible academic arguments that enabled the government to refocus its arguments. And I think when you get a result, a split result like this, 8 against 3, then it's a little difficult to say it was a waste of time and money. 3 of the most senior judges in the country found the government's arguments persuasive and attractive.
Yeah, all right, for the moment, Clive, thank you very much indeed. That's Clive Coleman there, our legal affairs correspondent. Let's get more political reaction, more of the political ramifications of this Supreme Court judgment we've had here today. Our chief political correspondent, Vicky Young, is with me here at Westminster. Vicky.
Well, it's certainly the case that if the government hadn't appealed that, they would have had longer to meet their timetable, but they seem pretty confident they're going to manage it anyway. Now, Parliament will be centre stage, at least for the next few weeks, but there are few here who think that actually Article 50 won't be triggered. Let's discuss this a bit more. I'm joined by Labour's Pat McFadden and for the Conservatives, Kwasi Kwarteng. What does Labour hope to achieve here? We've heard Keir Starmer talk about a meaningful vote at the end of it. What does that mean?
Well, I think today is a humiliation for the government. They have been defeated not once but twice in the courts in an attempt to deny Parliament any say whatsoever in the triggering of Article 50 and what happens after the referendum. What Labour hopes to achieve is a proper debate on what happens when we leave the European Union, and that will involve big questions around jobs, trade, investment, and what kind of deal we get at the end of the 2-year negotiating process. And that's a perfectly legitimate job and indeed duty for MPs to carry out.
The government's been trying to sideline democracy.
I don't think that's the case. Pat was in the House, as I was, when we passed a referendum bill which essentially handed over the decision to the British people. That's why we had a 4-month campaign, and it was a very keenly fought referendum, and in the end there was a decisive verdict. Now, there were 2 different views as to whether Parliament then needed to have a further vote. The Supreme Court today has said that Parliament should have a vote. Personally, I didn't think that was necessary, but that's been resolved. I think the vote will take place very quickly, and I suspect it'll go through both houses without too much controversy.
And that's the truth here, isn't it? I've spoken to lots of Labour MPs, some who are ardent Remainers, who say they will not block Article 50. Labour's in an incredibly difficult position here, isn't it? Jeremy Corbyn is going to order his MPs to vote for Article 50.
I think the drama of the court cases and these heavyweight judges reading out the verdicts has perhaps built this up into a moment that it might not actually be. I think there's a majority in the House for triggering Article 50, but I also think that, like any legislation, this is subject to debate, to scrutiny and to amendment.
But if it's just one line or a one-line bill, in the end, what can you change in it? OK, a white paper, but that's still not going to bring about our membership of the single market as some want.
Well, let's see what the legislation actually says. My own view is I think that the beginning of this process is not the only important moment. I think as we go through it, the end of it might also be an important moment. The Prime Minister said in her speech last week that if she didn't get a deal she liked, she would walk away, rely on the World Trade Organization rules for trade, which have got quite big implications in terms of tariffs, lack of common standards, potentially big barriers between us and our biggest market. So I think that what comes out of this at the end of it is very important, and I think that attention may quickly switch from the process questions around Article 50 to the substance questions of the deal that we get outside the European Union.
I think Pat's right, but I think what Labour and a lot of people seem to have forgotten is that the discussions are a two-way process. We can decide what we want, but at the end of the day, it's the 27 countries that still are in the EU that will also have a say.
So you're saying you can't bind the government in law?
Yeah, I mean, I hear lots of things about amendments, binding the government to do this, that and the other, but there's no way that in a discussion you can, between two parties, that anyone can just bind one party unilaterally to one course of action without any reference to what the other parties are saying.
Can Parliament have a say in the type of Brexit that happens?
Well, the Prime Minister has said that at the end of this process, and Pat knows that very well, that there will be a vote. There will also be a vote, extensive debates on the Great Repeal Act, the Great Repeal Bill, which will look at the whole body of European law. So I think to say that Parliament isn't involved in this process, I think is not quite right. I think Parliament's very much involved.
Do you agree with that?
But it's precisely because it's a two-way process that some of the claims made by the Prime Minister in her speech last week need to be tested. The test for her, the bar she has set herself, is that she can negotiate outside the European Union the same level of access for our goods and services, not just about tariffs, but about common standards and the rights of access outside that we currently enjoy inside. It's perfectly legitimate for MPs to press her on how she's going to do that and to critique her if she fails to do it.
You will vote to trigger Article 50, you personally?
I will not vote to block Article 50. I respect the referendum result. I understand that that's what people voted for, but I don't think debate and discussion ends with the triggering of Article 50. I think the type of deal is also an important duty for us to discuss.
I think Pat's right. I think the idea that Parliament would somehow overturn the referendum result, which everybody in the world saw what happened in June, and the idea, I go around the world saying we should respect democracy, we should foster democracy. The idea that this Parliament is going to overturn the will of the people, as expressed in June in this way, I think is ridiculous. I also agree that there has to be debate. I think there's been plenty of debate, and we're going to have more debates to come.
Okay, thank you to the both of you. And David Davis has made it clear that the process of that bill coming in could start as soon as next week.
Vicky, thank you very much indeed. Let's continue that discussion with Conservative MP Oliver Letwin, who joins me now. First of all, your reaction to the Supreme Court judgment. Do you think that was the right judgment, that Parliament should trigger Article 50 rather than the government?
Well, it's for the Supreme Court and not us to judge what the law is. I think it was very much the expected judgment.
What happens now? Because David Davis has said, as we saw, the government will introduce shortly a straightforward bill. But will it be straightforward getting that bill through Parliament?
Well, I think the risk is that people will try to put down a whole pile of amendments that would tie the government in legal knots while it's trying to negotiate a deal which is the best deal it can get for the country. And that has to be resisted completely. I think we have to have a very simple bill that stays simple all the way through its process. I think that would be very achievable in the House of Commons, where I think there's a very strong majority in favour of that. It may require a great deal more heavy lifting in the House of Lords.
The Scottish National Party, we were talking to Alex Salmond earlier, he said they've got 50 amendments ready that they're going to put to any bill that's introduced.
Oh yes, the ingenuity of those who are intending to subvert the process of exit is limitless. And we just have to make sure that they don't succeed in achieving their end.
But it could delay the process, couldn't it? That sort of multiple amendments could delay it.
Well, not in the House of Commons, I think, because there's also a sufficient majority, I suspect, to get timetable motions that will enable the bill to move forward in a proper way. Again, in the House of Lords, where I don't pretend to understand the arcana imperii of the House of Lords, a very, very strange institution, but my understanding is that you can do an awful lot to spin things out, and therefore, actually, I think the government and those of us who want to see exit proceed, even though in my case I voted to remain, I think that's where we need to go now as a country, will need to keep up maximum pressure on those in the House of Lords that would otherwise seek to pervert the course of this.
And as a Remainer, do you feel across the whole Brexit process, 2 years or whatever it is, that there needs to be full parliamentary scrutiny?
Well, parliamentary scrutiny is one thing, but Parliament derailing the process of negotiation is quite another. I mean, I was for 6 years a cabinet minister. I am very well aware that a government cannot be expected to negotiate something as complicated as this if it's constantly having to negotiate with Parliament as well as with opposite numbers in the rest of the EU. So I think we have to give the government the free hand it needs. Theresa May has set out a very clear programme of objectives. Delivering those objectives requires an enormous amount of negotiation. We have to let the government get on with that.
All right, Oliver Letwin, grateful to you for your time. Thank you very much for being with us here outside Westminster. Well, that is the latest from here as politicians begin to digest the implications of that judgment from the Supreme Court, 8-3, that Parliament must trigger Article 50, not the government by itself. Simon and Anita, back to you in the studio.